Hello, everyone, and welcome to today's webinar. From the Provider Perspective, Updates on Contingent Workforce Laws. Well, back in April, we presented the risk and rise of contingent workers. We had thousands of attendees and received hundreds of great questions. And we're back for another round of contingent workers. But today we're going to look at it through the lens of providers, staffing firms, PEOs, AORs, and EORs. What are their challenges? What do they need to be prepared for? We have a great session lined up with an expert panel of Littler shareholders and core members of their staffing, independent contractor, and contingent workers practice group. This panel will help you understand the risks associated with contingent workers and how to best prepare for it. I'm Michael Worth. I'm the Vice President of Sales from ComplianceHR. We know how busy your schedules are, and we greatly appreciate the fact that you can take an hour to attend our webinar. So thank you very much. You all know Littler Mendelson as the world's largest employment law firm with over 1,800 attorneys and more than 100 offices around the world. They only practice employment law, and they are continually recognized as innovation leaders. I'm happy to see how many ComplianceHR clients are attending today's webinar. Thank you for being our client, and thank you for attending today. For those of you who are not familiar with ComplianceHR, we're a unique combination of a technology platform called Neota and Littler. There's no Googling or guessing. Users quickly refuse accurate and up-to-date information regarding employment rules. Our goal is to simplify the complexity of employment law, and we do that by offering a suite of technology solutions around critical HR compliance topics. Whether you're creating and updating handbooks, looking up paid sick leave, or even doing exempt, non-exempt classification, we provide on-demand, self-service, expert advice all the time. So today we're going to talk about Navigator Independent Contractor. This solution is loaded with all the federal and state rules, and Littler analyzed thousands of cases and opinion letters, and that logic is built into the solution. Users enter their fact pattern, and they receive a risk analysis on a federal and state basis. They receive an analysis on how to lower their risk. We start by providing what the actual rule is, and then we apply, your response and how you could potentially get a better risk analysis, and we give you a transcript of how the whole solution was answered. Now, our clients have run over 8,000 Navigator independent contractor evaluations over the last few years, and I'm happy to share their successes and methodologies on how we've used this in the past. If you're interested in a free trial of ComplianceHR, please select yes to the polling question that's in front of you right now. You could also go and select the free trial button at any time during the webinar. When you sign up for a free trial, we'll coordinate a brief meeting to discuss your requirements, review Navigator Suite functionality, and then we'll let you use Navigator IC on your own to test out the classifications that you currently have in place. So as always, we would love to have any of your questions you can put in the Q&A box. We'll try to answer them at the end or send follow-up. Everything will be recorded, and after this meeting, we'll go ahead and we'll send this off to all of the attendees. I would like to give a warm welcome to our panelists and experts from Littler. Josh, Michael, Emily, Joy, welcome. Josh, I know we have a very full agenda, and I'm pretty sure you'll talk about this later, but platform business models are frequently used by providers, and many of our clients use Navigator solutions to help supplement their models. I was hoping you could maybe provide some insight on how these use cases might develop. Josh?
Thanks, Michael. Appreciate it. So ComplianceHR, and in particular, the Navigator IC model, gives you more tools in your tool belt. And platform clients tend to be bigger users of the Navigator IC tool, although by no means are they the only users of that. But the way that my platform clients are using that is that they're making classifications of workers who are, say, independent contractors on their platform looking to connect with clients. Or the clients will ask, hey, here's an engagement. Is this in more of an employee engagement or more of an IC engagement? And what the way the platform models are leveraging your tools over at ComplianceHR is to say, look, we can run this through that Navigator IC tool and give us a good indication of whether this should be an independent contractor or employee classification. And of course, they could do that for all the workers on the platform, or they can group them. So this type of worker in this state, we're going to run it in this way, and so that they can gain some more scale out of that sort of tool. So platform business models, as you can see, is on our agenda. We're going to actually come back full circle to that at the end. But what we're going to start with is investigations and reasonable accommodations. Joy's going to present on pay data reporting. Mike is going to give us some updates on another hot topic. We're getting tons of questions on the New Jersey and Illinois temporary worker rights laws. And Emily's going to weigh in on staffing agency registration requirements, which are popping up more and more, and we see an upward trajectory on. And like I said, we'll close out with some thoughts on platform business models. Look, we're covering 5 topics in 60 minutes, right? And so this is meant to be more than just a simple issue spotter, because a lot of people, if not all people on this call, are into the contingent workforce issues. And so simply an issue spotter for 60 minutes is not the most help. However, we decided to cover 5 topics, and we're going to do an issue spotter plus. So we're going to take a couple steps beyond that to ask, are you looking at the right things in your business to mitigate risk, to educate your internal business clients on what the risks are and develop best practices? But we decided not to, for instance, do a full 60 minutes on pay data reporting or platform business models, which would be extremely easy to fill the whole time on that. So we're trying to balance the issue spotting with a few steps deeper than that. Now, I'm starting with one that actually got a ton of good, lively conversation at our executive employer in May, which is hosted in my hometown of Phoenix, and we hope that you can make it out to those. We also have regional employers often in the fall at all of our Littler offices. So if you're not on the mailing lists for those, please let us know, and you can come get a full day of continuing education and some of the hot topics. One of the hot topics that generated a lot of discussion was this idea about investigations and interactive process for reasonable accommodations when it comes to staffing providers. Why is this important to talk about? Well, the EEOC is focusing their enforcement on contingent workers. They have several enforcement areas, and one of them is contingent workers. And we're seeing the results of that. We're seeing some rather high settlements or verdicts in the employment law context that involve staffing agencies, third-party recruiters, headhunters, those sorts of things. And so these are some of the last few years, some of the verdicts or settlements that we've seen involving the EEOC going after contingent worker situations where it's the provider and the client together. Now, I mentioned that the EEOC has identified contingent workers as one of the areas of enforcement, and this first bullet point here is directly from the EEOC Strategic Enforcement Plan, saying that the one area of emphasis for them is going to be temporary workers, staffing agencies, independent contractors relationships, and the on-demand economy. And so this is not just us nerding out about this, because this is what we do, and this is the practice area that we get excited about, but this is actually coming straight from the EEOC saying this is one of our focuses. And I think they listed about, I don't know, it's like 5 or 6 or so. So it's not like they gave us a list of 25 areas of emphasis and that list didn't have much meaning. They identified this as one of their areas that they really want to focus on. The one thing that we want to do when it comes to mitigating risk and increasing compliance when it comes to the EEOC enforcement is in your contracts and providers, this goes both ways. And part of our discussion at the executive employers was this goes both ways. Clients and staffing providers will be protected by incorporating a duty to report into their contracts. The nightmare scenario that unfortunately we do get fairly frequently throughout the year is we get a end client call us, or we get a staffing provider, whether that's EOR, AOR, PEO, staffing firm. We get a provider that calls us and they say, this was never reported to us. We've now got an EEOC charge for race discrimination, sexual harassment, age discrimination, disability discrimination, failure to accommodate, the the complainant, the charging party, is saying that they complained to one or the other, the end client or the staffing provider. But we get a call from our client that says, we never heard about this. And so we would encourage you to incorporate into your contract a duty to report any claims of illegal activity, included but not limited to harassment, discrimination, failure to accommodate. We also, obviously that's the focus of this presentation, we also include health and safety, unethical conduct in there. And so that's one of our tips for mitigating risk to meet the EOC at their strategic enforcement emphasis. Duty to engage in the interactive process. So staffing providers, I realize there's some AORs which are engaging people on a 1099. But for EORs or staffing firms or PEOs, we should set out who is going to take the lead on the interactive process and a requirement that the other party, so if it's a staffing firm, because if you're W-2ing them, you should be taking the lead on the interactive process, and that the other party, the end client, has a duty to reasonably cooperate with that. Now, how is this going to play out? Well, we've seen it play out well in some circumstances, and we've seen other circumstances where the end client is refusing to participate in that process. And it's a hard situation. Give us a call. It's a hard situation to get through. But if you incorporate into your contract the duty to engage in the interactive processes on the W-2 employer, and that the end client is responsible for reasonably cooperating with that, then at least you've got a framework to address a reasonable accommodation request. When it comes to investigations, this was another topic that generated a lot of discussion. So there's a couple of schools, there's a couple of camps here, and I actually think that through talking to our clients and presenting at these presentations that my view of this has evolved a little bit. One camp is whoever the alleged bad actor is, whoever the complainant is, whoever employs the complainant should take on that investigation. In other words, you have an employee who's coming to you complaining about harassment, discrimination. You need to investigate that. I wholeheartedly agree with that. Haven't changed my mind on that. You need to take the lead on the investigation. There's a school of thought that says if both the complainant and the respondent, meaning the alleged bad actor, are with one party, the end client or the provider, in your instance would be with the provider, that you should take the provider should take the lead on the investigation on that. What the end client ends up saying there, so let's say that the staffing provider is doing the investigation, what the end client is worried about is that these claims they appreciate that you're doing the investigation. They should defer to you on your investigation of your own employees, but they also are worried about the environmental impact of these on their workforce, because harassment or discrimination claims can have environmental components to them. And so they may also conduct their investigation. And so a lot of our larger institutional clients have investigation teams already set up, and they're going to investigate, and they may conduct a parallel investigation to you, staffing providers, who are investigating your employees making complaints or being accused of discrimination or harassment. That's okay to have the parallel investigations. One best practice that we suggest is that if you need to interview somebody from the other side, so providers, if you need to interview somebody from the end client, the end client side, that you notify them and allow HR an opportunity to attend that. Now, they may refuse to allow that interview, in which case you'll just have to note that in your investigation and make any conclusions that you need to, and we run into that often with investigations, but we do think it's a best practice to go ahead and notify them that you're going to conduct that investigation. So a lot of the providers that I've talked to say, trust us to investigate our own employees, and I think that's right. Trust us to investigate on behalf of our own employees who complain. I think that's right. But don't be scared off if the end client also wants to conduct their own investigation into how it impacted the work environment where you had placed those workers. So interesting topic. Happy to discuss it more with you. You're free to reach out to us after the webinar or catch us at one of our regional employer presentations. I'm going to move on to pay data reporting and turn it over to my colleague, Joy.
Thank you. Good morning, everyone on the West Coast, and afternoon to everyone on the East Coast. I want to make sure I include everybody there. So let's start with this new requirement, California's new pay data report. First off, why are we talking about just the California law? Well, because where things start in California, they do tend to catch on in other states. We call it California Contingent. So we've got a pay data report obligation that's been in the law since 2019. Why are we talking about it now? Well, Senate Bill 1162 in California significantly amended this pay data reporting law, and it includes a lot more employers now, and it includes use of labor contractors. So a little bit of history. When we first got our pay data reporting law enacted in 2019, the staffing industry was able to really carve themselves out of that law. Fast forward to a couple years later, and in 2022, the legislature said, hey, you got a break in 2019. We're including you in this new law. You are now included in the pay data reporting. So that's where we're at today. Essentially, what the law did was remove this tether that we had to an EEO-1 filing. So most of you are familiar with an EEO-1 report. If you have filed an EEO-1 report, then you had to file a California report. Now California report says forget the EEO-1. You have to file regardless. If you are an employer in California that has 100 or more employees enterprise-wide, at least one of which is in California. And now it includes employers that are using labor contractors as well. So they have to file another report. So if you use 100 or more labor contractors, at least one of which is in California, that employer must file pay data on all of those labor contractors. So that's kind of where we're looking at. Let's look at sort of the new framework of disclosures. So the Civil Rights Department, formerly the DFEH, is saying you may potentially have to file two reports. So the employer's pay data report and the labor contractor employee report. So if you are a large employer, you might even have to submit two reports if you not only have 100 or more employees, at least one of which is in California, but also if you use a significant number of labor contractors. So considering the audience here, many of you have probably received a request from your client saying, hey, labor contractors are included in our pay data report this year. Please turn over this information. And we'll go into some of those requirements here shortly. But some of the new additions under Senate Bill 1162 that are pretty big are the mean and median pay and the demographics are now broken down in the employer's pay data report. So prior it was mostly demographics. Now you're reporting on the actual pay. And then in addition, the employers have to disclose who they're using for labor contractors, so the company names, and the wages that those labor contractors are paying to their employees, as well as the demographics of those individuals. So this is all part of the big umbrella of pay transparency in California. So another part of pay transparency that you're seeing nationwide is the pay scale disclosures on job requisitions. That's one chunk of pay transparency. Another one that's really starting to take off is, hey, tell the government what you're paying people, and then the government really will analyze this and then provide you, the employer, a graphic after these reports are filed of who you're paying and what the demographics look like. So let's get into a little bit more of the details here. What is a labor contractor? So the legislature has assigned a definition of labor contractor specifically for purposes of pay data reporting. It's very broad. It's right here and very simple. I mean, any individual or entity that essentially supplies that employer with any form of labor, regardless if they have a contract or not, so long as that labor is in the employer's usual course of business. So this has been a struggle of a definition because the Civil Rights Department has no regulations defining this. What they have are frequently asked questions, FAQs, that they have revised multiple times, and that has led to some frustration in the staffing industry, especially because it keeps shifting. So here is what it currently is. The client-employer usual course of business now means the regular and customary work. Okay, well, what is that? So the Civil Rights Department has broken this down to say any work that's performed on a regular basis or of a routine nature that is either critical to your business or necessary for its preservation. So it doesn't include any isolated tasks or one-time tasks. Now, these examples are going to throw you for a loop a little bit because, at least to me, they're counterintuitive. The Civil Rights Department has given an exemplar of a janitorial service. So if you're a big box store and you sell retail goods and your janitorial service comes in on off hours to clean that facility, are they in the usual course of business? Well, the big box store is not in the janitorial business, so it doesn't really make sense that they would be reporting on that janitorial service, but the Civil Rights Department said actually they do because it is necessary for the maintenance of your business. Another example is an audit. If you are hiring an audit for your business because you need to look into the financial health or there is something going on that you're trying to unearth, to me, your financial health of the business seems like something that might be pretty critical for its preservation. However, that is an example of something not in the usual course of business because it's a one-time thing. So sort of an odd carve-out here. The Civil Rights Department said, okay, employers, you are only reporting on labor contractor employees. So when you contact your staffing companies or any other labor contractor companies, you only want the data on their employees, so they're W-2 employees. If they're 1099, they are not going to be included in the reporting. So this often gets confused because employers say, hey, I'm paying our staffing agency a lump sum of money. I don't know how they're paying their staff. Well, that is not good enough. The CRD is requiring those employers to go to the staffing agencies and request the data, and then you guys are then providing that information to the client employer. So here is a breakdown of what you need to supply. Now, I realize this is quite a bit, but also rest assured that when you are providing this data to the client employer, it is de-identified and it's prepared in aggregate. So even though it says here the name or the employee ID of the worker, oftentimes when you get these requests from the client employers, you are getting a list of names or maybe shifts, dates, and times, or simply locations to say, hey, please report on these individuals. When you compile this information and you give it to the employer, individual names won't be on there. If it is one person or three people such that they could be identified, I recommend using an employee ID of a worker. And then you'll also need to break it down according to their job description, their title, and then the EEO1 job category. And new is that you are breaking down race and gender and then wage information as well. So it will then have you list, for example, who are the race and genders, and then broken down what kind of wage information is it according to race and gender. Because really the Civil Rights Department is getting at, is there a discrepancy between how people are paid broken down by their demographics? So here's a bit of a twist. This is an issue that we encounter often. If a contract worker only, say, gave you 20 hours during the year, you're only supposed to be reporting on 20% of their pay from the W-2. So how do you do that as a staffing agency? Unless you are tracking exactly how many hours is attributable to a certain client employer, many staffing companies are turning over all of the data and then having the client employer break it down according to assignment. So we can work with you on that if you are struggling with it. So the labor contractors, and that would be really for the most part, you guys, when you're in the role of receiving that letter from the client employer saying we need this information, this is essentially what they are looking for in order to prepare their report. So they need how many hours, hopefully you're tracking, paid for the time spent working for that individual, the location where that staffer is assigned, and then the legal entity, which is something that we can also help with as well, to which the worker was assigned, and then the name of the labor contractor. And this often gets misconstrued. When we say name of labor contractor, we mean the name of the business. So ideally, in a perfect world, the labor contractor provides a report in Excel of all of this data that the CRD requires, and they email it off to the employer. The employer files it. The employer is likely getting many reports from many staffing companies, and they are compiling them all together and merging them. That is their responsibility. Your only responsibility is to provide the information that the CRD is asking for, not extra information that the client employer wants, and they often ask. So there is an exemplar on the CRD's website of specifically the Excel sheet that is what you would need to fill out. We recommend just sticking with that. A lot of the time the employers want more information and they're not entitled to it. So these are some of the common issues that we get from client employers that are trying to get data from labor contractors or staffing agencies or any third party really that they've contracted with that they deemed as performing work in their usual course of business. So employers feel like they are getting their letter ignored, or the labor contractor disagrees with the letter. These are common issues. Many employers are filing their report anyway, and they are listing the labor contractor who ignored the letter or disagreed with the letter, and they're leaving it up to the CRD to determine, are they going to investigate and assess a penalty. So a problem here is if you ignore that letter asking you for data, then you can be penalized for failing to provide that data. The CRD has the ability in the statute to assess penalties. The penalties are $100 per person enterprise-wide for the first violation, $200 per person enterprise-wide for the second. I have not yet seen a ton of enforcement activity, but the Civil Rights Department's a little bit underfunded, so they will catch up. Another common issue is if you disagree with a letter that you have received from a client employer, disagreeing that you're not within the scope of their usual course of business, that is something you want to document in writing or over an email exchange so that you have a justification if the CRD comes to you. Now, another common question is, does this apply to contract workers in other states? So yes for the count and no for the reporting. So when you are determining whether you have to either file your own report or you have to file a report on your labor contractors, you look to labor contractors in California and throughout the U.S. to determine if you have 100 or more, at least one of which is in California. If yes, you're covered under the requirement. Now, when you file with the CRD, the information you give to the Civil Rights Department will only be pertaining to those California-based labor contractors or labor contractors reporting in regularly to a manager or supervisor in California. Almost wrapping up here, another common question we get is, well, we only had 80 or 98 employees or labor contractors. So that is not an easy out, unfortunately, because if you regularly have 100 or more, but you dipped to 98 or 80 during the reporting period, the CRD is taking the position that, well, if you regularly employ 100 or more, you still come within the confines of the reporting. So that would still be a requirement to file. Lastly, so if you didn't file your own employer pay data report this year, the portal has closed. I would focus on just making sure you comply with next year. If you get a letter from the CRD saying, hey, you didn't file as an employer, contact us. But if you are a staffing industry representative that received a letter and did not produce the information to the employer, just take a wait and see approach and see if the CRD contacts you. The investigations are very slow. There has only been one press release publicly to basically shame a healthcare company that did not file an employer report. So we haven't yet seen enforcement on the labor contractor reports. I think DCRD is dealing with a lot of data, and they are not quite sure what to do with that. So that wraps it up. I'm going to do my best to answer as many questions as I can in the chat, and then I will turn it over to my next presenter to talk about Illinois and New Jersey.
Thanks, Joy. Mike Gotzler here. Thanks for joining, everybody. Our next topic is definitely a hot topic. So when we were choosing topics for today's presentation, we were really challenged. There's so much happening right now in the staffing space across the country. We chose this topic because of its urgency. These two new state laws really represent a sea change in the staffing industry. As a former general counsel of a staffing firm, I was delighted to see this topic make the cut, so to speak, for today's agenda. As Josh noted at the outset, our contingent workforce practice group here at Littler has been extremely busy over the last month advising staffing firms and also clients of those staffing firms on these two new state laws. So let's jump right in. We're really going to focus on these two states, New Jersey and Illinois. As of right now, these are the only two states in the country that have laws on the books that require staffing agencies to pay equal pay and equal benefits to its assigned employees. And those equal pay and benefit requirements are in relation to the client's employees, its own internal staff, who are performing what these two state laws call substantially similar work or performing substantially similar duties. Now, there are other aspects to these two new state laws in New Jersey and Illinois beyond the equal pay and equal benefit requirements. Both of them also focus and prioritize workplace safety issues, workplace training, both before employees are placed on their first day of an assignment with a new client employer, and both contain a significant number of notice requirements, not just with the staffing agency, but they also require new notice provisions on the client end user side of things. So let's take a quick look at New Jersey. This is only a summary slide, as Josh noted at the outset. Time really doesn't permit a super deep dive, but I will call out to everybody that our practice group has on the Littler website under News and Analysis a significant number of Littler ASAPs and insights on both of these two new state laws and proposed rules that have issued in both states that provide much more detail. I've answered many questions in the chat already that drill down into some of that detail. Again, we suggest you take a look at those Littler resources on our website. They're accessible, free to the public, and of course, follow up with us if you have any questions. So New Jersey went first, so to speak, and early in the calendar year enacted the Temporary Workers Bill of Rights. Again, the primary focus and purpose in this new law was the equal pay and equal benefit requirement for assigned employees. So you might be asking, which industries does this apply to? In New Jersey, and there's a difference between New Jersey and Illinois, and again, take a look at the Littler resources I just mentioned for a fuller, detailed list of which industries are included and excluded. But generally speaking, in New Jersey, we're largely talking about blue collar, so to speak, type industries where this equal pay and equal benefit requirement exists. So in order to satisfy this obligation, a staffing firm is going to need significant amount of data from its client, of course, right? So that the staffing firm has the data it needs to start paying assigned employees equal pay and equal benefits. We've answered quite a few questions from clients, of course, of staffing firms who have asked, why does my staffing firm partner need this information? Well, in both New Jersey and Illinois, it's a statutory requirement so that the staffing firms in those states can fulfill their new obligations. The New Jersey law also prohibits agent staffing firms from charging certain types of fees to assigned temporary workers, including certain meal fees, transportation fees. And again, I point you to Littler's July 27th insight that goes into detail. The New Jersey Department of Labor issued some proposed rules that get into some of the weeds a little bit on how this New Jersey law is supposed to work. For example, there is some guidance, not the level we'd like to see, but still some guidance about how a staffing firm is supposed to calculate hourly rate when it comes to equal pay and equal benefits. So again, take a look at those resources. Over in Illinois, a little later to the game here in 2023, it amended a long-standing statute. Fortunately, that statute, like the one in New Jersey, is limited to certain industries. This Illinois statute has long excluded what it calls professional or clerical work. There's not a lot of guidance out there or case law through the years that expounds upon that exclusion, but take a close look, determine what types of assignments actually are covered by this act and this very new and broad-reaching equal pay and equal benefit requirement. Unlike the New Jersey statute, which applies immediately on the first day of a temporary employee's assignment, the Illinois amendments for equal pay and equal benefits only apply after an assigned employee has been at a client location for 90 calendar days. But be aware that is not 90 working days. It's also 90 calendar days in any 12-month period. So you could have coverage if an employee worked, say, 6 weeks in March and April for client A, was assigned elsewhere, went back to client A in the fall and worked another 7 or 8 weeks. The math may work out that the 90 calendar days requirement has been met in that type of a scenario. Like New Jersey, the Illinois Department of Labor has issued proposed rules that are fairly helpful. In Illinois, those were issued in early August. Again, Littler issued a insight that's available that takes a closer look at those proposed rules. Actually, in Illinois, they're emergency rules. So those actually took effect and are in place now in Illinois. There are additional safety requirements in Illinois. So, and they all need to be very well documented to satisfy these new statutory obligations. There's training requirements on the staffing agency side, and there's safety and training requirements on the client end user side as well. One of the most concerning things about the Illinois amendments is that it expands a temporary employee's private right of action. and which did not exist previously. The statute used to be a civil enforcement and penalty type consequence statute. That is no longer the case in the state of Illinois. Not only that, but the statute has, the amendments have some language that indicate a so-called interested party, end quote, can also bring a private right of action against a staffing firm that allegedly is not in compliance. So in other words, I think most have read that to mean a labor union, for example, could bring a private right of action in the state of Illinois under these new amendments. Yes, and here are the emergency rules that I just mentioned. One of the helpful nuggets, if you will, from the emergency rules, that second bullet point, you know, the Illinois Department of Labor took a stab at defining what equal benefits actually means. You can see there that it's in a very broad definition. We're talking about not only employee benefit plans, but we're also talking about paid and unpaid leave. So again, broad in scope. It will require extensive information sharing between the staffing firm and its client employers in the state of Illinois. So again, a quick summary of these two new very important statutes. Now, fortunately, they're the only statutes in the country that have this equal pay, equal benefit type requirement right now. We haven't seen the so-called California contagion just yet that Joy spoke about as to pay data reporting, but there's every indication that other state legislatures will pursue similar new obligations on staffing firms. Again, this is a new way, so to speak, a sea change, however you'd like to describe it. The staffing industry and its primary trade association, the American Staffing Association, have been very engaged in both states as best they can. There is litigation pending in New Jersey to prevent some of these requirements from taking effect. That litigation has not been successful so far. So it's best to plan as though these will take full effect, and some of these requirements are already in full effect. Again, this is not just an issue for staffing firms, but in both of these states, there are new obligations for clients of staffing firms as well. So it's really important that staffing firms continue to partner very closely with their clients and to best protect both of them and really have clarity about who's responsible for what. With that, I'm going to turn things over to my colleague, Emily Linn, who's going to talk to us about staffing firm registration at the state level. Emily, take it away.
Thanks so much, Michael. Hi, everyone, and thanks so much for joining us. The staffing firm registration requirements are deceivingly complicated. And I discovered this when, I signed up for a research assignment where, we kind of did a national research assignment for a client on, what are the rules nationally for staffing firms. And they're complicated because, of course, there's no federal standard. Instead, what we are left with is looking at state statutory and possibly regulatory authority to determine, whether registration is required in a particular jurisdiction. And then if registration is required, what that process looks like to get a license or certification. And then what kind of exposures or penalties may result from noncompliance. As well as, and particularly, we're worried about noncompliance because a lot of these state rules have renewal requirements that, we often forget about. So, it's going to be a state-specific inquiry. And just to flag, we don't have time, unfortunately, to talk about registration rules for recruiting firms and PEOs, but that's a similar complicated inquiry because the rules are state specific, right? So if you are a staffing firm that's performing work in multiple jurisdictions, this becomes a complicated inquiry very quickly. With that being said, when you are looking at a particular jurisdiction's regulations, there's a few things that we wanted to flag for you. The first is to pay attention to statutory definitions. Usually, these licensing or certification rules have broad definitions. For example, they say employment agency or placement agency, and then you're left with kind of a very broad definition, and you will have to do that analysis of if your business falls within the scope of that particular rule. There's also typically lots of exemptions because, it can never be easy, right? Many states have exemptions where they say registration isn't required if, you're in an established educational institution, or you're a religious or charitable organization, or maybe you're performing free employment or consulting services with no fee. I know that's not most of the people on the call, but those are fairly typical in these state rules. But we also see some unique ones. For example, in Michigan, their licensing statute says that it doesn't apply to businesses who are procuring work for athletic events or concert theatrical performances, and they even throw in circuses. So, again, it's really, really important to look at the jurisdictions in which you're performing staffing services and look at those, not just the definitions, but also the exemptions. One key exemption that we wanted to highlight is that there are a number of jurisdictions that say if you are a staffing firm, but you solely receive fees from the client employer, not the applicant or the individual that's performing the work, then you don't have to have that license. Of course, that exception kind of overtakes the rule, right? That's usually what we see our staffing firms kind of structured as the client is paying that fee. So that's a very significant exception. But of course, not every state has that, right? For example, the Illinois Day and Temporary Labor Services Act doesn't have that registration exemption. So again, kind of a broken record here, but it's a very state-specific inquiry. We really do have to look at the rules and what they say, and what they say, doesn't apply. If you have particular questions about jurisdictions that you're in, we're happy to help you with that analysis because it does get complicated. Now, with that being said, we wanted to give a little bit of a preview. I want to say at the beginning, big caveat, this is currently the state of affairs. This is an emerging topic. We're seeing lots of legislative activity in this area. So just because I'll pick on my home state of Texas, just because Texas is gray right now, meaning that it doesn't have any current licensing rules applying to staffing firms, that doesn't mean it's always going to be the case. And that also doesn't mean that that's the case for recruiting firms and PEOs. Again, this map is just talking about staffing firms. With that being said, in the light blue, we currently have 21 states with licensing rules. Talking generally again, please look at the state-specific statutes and rules. But typically, registration is completed through a state's Department of Labor or similar organization. In Texas, it would be the Texas Workforce Commission. There's an initial application process and then a renewal. And what I've seen is it's either annually or every other year. There's an application fee that's associated with registration, and then some states have that fee be tied to the size of the staffing firm, and others use kind of a flat fee approach. It really depends. Usually the forms that you need to start the application process for your license are online, but some states you have to request those and have those mailed to you. So not the most modern or updated process. You'll notice on the map there's two states, California and Colorado, that are shown in kind of a navy color. They don't have a licensing requirement, but they do have other certification prerequisites. In California, each staffing agency must post a surety bond with the Secretary of State. And in Colorado, there's a separate kind of certification process where you need to prepare a list of worksite employers and their collective employees, information about their collective employees. And then in green, you'll notice that there are 3 states, and these are states that don't have statewide registration requirements, but they either allow or require registration on the local level. So throwing even more complication in, right? So specifically, Maine and Rhode Island are those states that say municipalities can license or regulate staffing firms, and then in Utah, it's a mandatory. So, again, this is just a guide to make you aware of the current state of affairs for staffing firms. It doesn't mean that this could change, because it likely will change. And then, of course, there are those definitions and exemptions within each of those states that are really important to consider. One other note is that there are some states that have additional registration requirements for particular types of work. The most prominent example is nursing staffing firms. We see a lot of states have specific kind of heightened rules for nurses. So again, deceivingly complicated, but we are here to help you if you have concerns about whether you are in compliance with the state, with your state's licensing requirements. And with that, I will pass it back to Josh.
Thanks, Emily. Okay, so let's finish up by talking a little bit about platform business models. Obviously, we could spend more than the full hour on this. Platform business models have all of the challenges of contingent workers, misclassification, joint employment, but then they have these sort of unique positions that they're in the market. Some, but not all, are on demand. And most, if not all, are trying to place themselves in a facilitator model, the neutral third-party facilitator between the independent contractor and the client who is engaging the independent contractor to perform work. And here are by no means an exhaustive list of what we need to do. We spend many hours getting the materials ready, user terms, things like that for platform models, analyzing risk and mitigation recommendations. But here are some of the takeaways. We've been doing a lot of these this year, and actually for many years, the platform models are a strong business model that we're getting a lot of clients in that space. So some of the do's and don'ts. Look, it's really important to lean into this facilitator model and to make sure that you're communicating that in your public-facing materials. So if you have things like you get on your website, if you're a platform model, hey, independent contractor, hey, freelancer, hey, independent professional, you get to control when, where, and how much you work. You get to grow your independent business. Access the network, kind of speaking to the clients, engaging the independent professionals. Hey, access the network of independent professionals, connect with independent talent. On the don't side, by contrast, the platform models don't want to say things like, we are hiring, join our team. That implies that you're working for the platform model. Come work full time. We offer a competitive salary. These are sounding very much like employer job postings, which, by the way, we don't want you as a platform model posting on the employer job boards for employment opportunities. Agencies that enforce this sometimes have subject matter experts that go after this, but more often don't in our experience. And so what they do is they look for this low-hanging fruit that says you're posting on a job board, it says join our team, it says we are hiring, you're offering full-time competitive salary, and they look for that low-hanging fruit and they just beat us over the head with that in the audits. So on the do's side, bolster your argument that you are facilitating this connection between independent talent and clients looking to engage them on a project basis. Along those lines, review your marketing materials. Sometimes legal or the business side will get together and do a pretty good job of this sort of structure of we need to stay out of the independent professional and client relationship as much as we can. We're the facilitator model. We're trying to connect and give a platform for people to connect and find each other. And then marketing materials go out and say the exact opposite. They say, this is why you should join our team. Our team's the best. We'll provide you training, those sorts of things. And it really starts to sink our argument when we're trying to defend this against a agency action claiming that we've misclassified workers or we're the joint employer. Continuing on the dues side, obviously if you're in this platform business and you've been in the business for a while, you already have user terms, provider agreements, client agreements. Give those a review, every year, every couple of years for best practices. This is an evolving field, and so we can kind of bolster those. If you're newer to this space, right, we get clients to say, hey, we've been operating for the last 6 months, 18 months, we're replacing, for example, nurses. Well, you might not have built out all of the user terms and agreements yet, and they can really provide important legal protections for you. So be sure that you get those documents done the right way. Assess your expansion into high-risk states. Look, some of you on this call are already in all 50 states. You're international. We get it. We do get a fair number of small to medium-sized clients doing this sort of facilitator platform type model, sending professionals into schools to complete services that the schools don't do, specialized services. And they're saying, well, we're currently in Florida and Texas, and we're thinking about expanding to New York and Massachusetts, and we're saying, hey, look, we're not here to say no, but what we are here is to have you go in with your eyes open, and here's the whole different ballgame that you're playing in those higher risk states. So along the don'ts side, I wanted to highlight a couple others because everybody could read the slide here, but I wanted to highlight the branding. That becomes an issue sometimes where the independent talent is out there promoting themselves as a representative of your platform. They're saying that on their social media. They're marketing themselves as that. They might be wearing your branding. They might be including your logos on things. So keep an eye on that. That kind of falls into the review your marketing materials portion as well. And then the last one I'll wrap up with, just to highlight a few here, is the training side. We get these questions all the time. Hey, we need to train them how to operate on the platform. Okay, look, if you have a tutorial about how to use your platform, that's one thing. If you're substantively training people how to do the work services that they're providing, that is a completely higher risk situation. So as you can see, lots to go over on platform models. I actually love working with the platform model clients. They tend to be on the cutting edge of a lot of these issues. We would love to help partner with you to review your best practices and provide risk mitigation. Most of our work has a very strong eye toward presenting risk and solutions to the business side as you're trying to work through some of these. With that said, we've got just a couple of minutes left, and I'll mention that, one of the ways to mitigate risk on a platform model is if you're offering classification services to your clients, which a lot of them are doing, which we think is a risk. There's no way around it. It's a risk to offer classification services. If you're going to offer classification services, you want to do it in a quality way, in a way that has a high degree of integrity built into your classification system, in a way that you can be accurate with those. Obviously, Littler's here to help you. If you're doing this on a scale, if you want a self-help tool, Navigator IC is part of the ComplianceHR suite, and it's a wonderful way to input your data into this and get high-quality guidance on the risk level that you're facing. With that, I'll turn it back over to Michael.
Thank you, Josh, Michael, Joy, Emily. Thank you for sharing all this great information. For folks who are still interested in a free trial of ComplianceHR, we have a polling question up again. Simply select yes, and we'll reach out to you and coordinate a meeting. I think the important thing is that when you go about doing classifications and try to identify where potential risk is, using technology tools that are developed by the world's largest law firm is a great way to start. They don't replace the lawyers, but they really help you identify where your greatest risk is, and they give you insight about the position that you may be hiring for. So simply by putting your fact pattern in, we test for the federal rules. Depending on what state you pick, we'll apply their rules. We'll give you guidance about where the potential risk is and how you could potentially work to reduce that risk. And then thank you again. There's a transcript that has all the information in it as well. We are at the top of the hour. So once again, I'd like to thank the Littler team for their great material and presentation today. I'd thank all of you for taking time out of your day to work with us. If you have any follow-up questions or any other information that you're interested in receiving from us or the presenters today, please reach out to us and we're happy to respond. Thank you again and enjoy the rest of your day.